offer
your preliminary objection.
Mr. Speaker, the motion is to the effect that this House considers the directive by the Chief of Staff, Honorable Julius Debra, in a letter dated 10th February 2025 with reference SCR/DA 85/85/01/A, and refers the matter to a committee of Parliament to inquire and report to the House, as the directive is inconsistent with good governance practices and has consequences on the rights of citizens as provided for under Chapter 5 and 6 of the 1992 Constitution. Mr. Speaker, these are the terms of the motion that he seeks to move. My objection to this motion being moved is to the effect that, one, the matters contained in the motion are matters that are sub judice because there is an application before the Supreme Court by one Henry Nana Boachi, who has sued the Attorney General, and he is seeking some remedies in relation to this same matter. So the matter is in court. And the citation of the case is Henry Nana Boachi versus Attorney General and Minister for Justice, J1/12/2025. And he's seeking some reliefs, a declaration to the effect that the directive is unconstitutional, some orders to the effect that, the directive should not be enforced, and even some compensation that he is claiming should be given. So those are the issues that are the subject of litigation in the Supreme Court. Now, once this matter is in the Supreme Court, he is saying that this House should also refer the matter to the Human Rights Committee of the House for a determination that the letter has the consequence of violating the rights of citizens. So my position is that, look, the matter is already in the Supreme Court. Why would you raise the matter in this House and also seek that this House refers it to a committee, and the committee will be engaged in a parallel exercise of determining whether or not the consequence of the letter is to violate the rights of citizens? The matter is already before the Supreme Court. And I also argued that what you are seeking to do, in effect, is to ask this House to engage in a judicial function, a determination that the letter violates the rights of citizens. So that's a judicial function you are asking this House to engage in. The nature of the work of committees is to ascertain facts. That's mostly what committees do. Not to make a determination of a violation of rights or not. The determination of the violation of rights is a function of the judiciary. So my objection to this motion being moved is on two counts. One, that is a matter that is already before the courts. And I don't see how we are going to move this motion and debate it without violating Order 1231 of our standing orders. And Order 1231 says that a member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way as may, in the opinion of the person presiding, prejudice the interests of parties to the action. Mr. Speaker, my contention is that if this motion is moved and we are going to debate this motion, there's no way that debate will not prejudice the outcome or the interests of parties in the action. There's no way. Because the very issue that the court is supposed to determine is the issue that we are going to debate and refer to the Human Rights Committee. Because we cannot just say, oh, we are referring to the Human Rights Committee. We have to debate the merits. We have to debate the merits. And in debating the merits, we will end up offending Order 1, 2, 3 of our standing orders. But the standing orders say that it is up to you as the Speaker, if in your opinion the debate will prejudice the interests of parties in the litigation, then we cannot engage in that debate. So, Mr. Speaker, I think that given the fact that the matter is already before the Supreme Court, that the parties in the court have interest, this is a matter that, is well known, I don't see why this Parliament should also refer to its Human Rights Committee.
Ayariga, take a look at Standing Order 1, 2, 3 again.
Yes, Mr. Speaker. What about it?
Yeah, you can read it together.
So a member or a person entitled to participate in a debate shall not make reference to any matter on which judicial decision is pending in such a way as may, in the opinion of the person presiding, prejudice the interest of parties to the action.
So at what point is the matter debated?
Mr. Speaker, that is the point.
After the motion is moved.
Mr. Speaker, that is the point I'm making. The point I'm making is that there are two grounds on which I am raising the objection. The first ground is that under our Constitution, we must not interfere with the work of the judiciary. Under our Constitution. So, if the judiciary is already seized with a matter, Parliament should not also take up that same matter and refer it to its Human Rights Committee. You will be interfering with the work of the judiciary. Under the Constitution, we owe the judiciary a duty not to interfere with their work. And my argument is that we taking up the matter and referring it to our Human Rights Committee to also inquire into will be interfering in the work of the judiciary. That's my first argument. And I'm saying that my second leg is that if we are to move the motion, it will be difficult for us to move the motion without making statements. Whether we are moving it, we are debating it, whichever way, we will end up prejudicing the interests of parties in the matter. So, if you combine the two grounds, my contention, Right Honorable Speaker, is that the motion should not even be moved. Because I know how he's going to move the motion. In moving the motion, he's going to marshal all the arguments. That is where the problem is. He's not just going to get up and stand on his feet and say, I move in terms of the motion paper, and then that is not what he's going to say. He's going to move the motion and marshal every argument. At what point do we arrest the statements that will prejudice the outcome of the interests of parties in the litigation that is at the Supreme Court? So it is better that we argue the grounds for the motion not being moved at all. For you to rule at that stage, then we move on. Otherwise, if we say let's move, the person moving, the person seconding, the arguments that they will put forward in moving and in seconding, all those will end up prejudicing the interests of parties in the litigation. So if you combine the two arguments, even though ordinarily you wait until the person is making a statement and you think the statement is going to prejudice the interests of parties, then you object. But here, I'm saying that the very language of the motion, already prejudices what it is saying we should do. What it is saying we should do, apart from offending the Constitution, we say we should not interfere in the work of the judiciary. In moving it, there's no way that he will not say things that will not prejudice the interests of parties in the substantive litigation. Why the hurry? Mr. Speaker, he came here in this House and requested to make a statement on this same matter. We objected but the Speaker gave him the opportunity and he made a statement on this same matter. Then somebody has gone to the Supreme Court on this same matter. And once the matter is in the Supreme Court, you come to this House and say this House should also refer it to its Human Rights Committee to make a determination whether human rights are being violated or not. I said that is an exercise of judicial function. This House can't do that. Those are my arguments. And that's why I objected. And I told him privately, I told him at the meeting with the Speaker where the motion was admitted, and the Speaker agreed that, okay, you go, you try to arrest it, let the ruling be given. If the ruling is that he should move it, then he moves it, then we debate it. And then if the conclusion is that we should refer it to the committee, the Human Rights Committee, we refer it to the Human Rights Committee. Mr. Speaker, that is my case.
Thank you very much. I would give the floor to Honorable Minority Leader to respond to the preliminary objection raised by the Majority Leader on the motion under reference.
Thank you, Mr. Speaker. This platform and Chamber of Parliament will always be a place to enrich knowledge and to learn. First of all, Mr. Speaker, in response to the preliminary objection, let me rely on Order 103F of our rules book. Yes, F, 103F. Conditions for admissibility of motion. Condition of admissibility for admissibility of motion. Mr. Speaker, our rules provide and a motion shall relate to a definite issue and not be the subject matter of an action on which a judicial decision is pending in such a way as may, in the opinion of the Speaker, prejudice the interests of parties to the action. Mr. Speaker, this motion has crossed the admissibility stage and has met the threshold of admissibility. Indeed, the Honorable Mahama Ayariga raised these matters. This was not the original text that was filed. We interrogated it to ensure that the outcome of this motion and the text thereto will not have any prejudicial effect on any matter in court. So, Mr. Speaker, the first leg of his argument falls flat. In any event, Mr. Speaker, with respect, the Supreme Court's writ is seeking an interpretation of the Constitution. Before you, Mr. Speaker, is not seeking a declaratory relief. My law in the minimum is not rusted. My law in the minimum, I kept quiet for you. Learned Majority Leader. Please. You have not heard me. Mr. Speaker, these things must stop.
Majority Leader.
I never said that. He is not paying attention. I'm saying that this motion.
Minority Leader, I may be called upon to give a ruling, so I need to understand very clearly. So the fact that the subject matter being a letter written by the Chief of Staff terminating appointment, as quoted in the motion, is actually before the Supreme Court for the determination of constitutionality or other words of it. Is that the case?
Mr. Speaker, that is not the matter. Mr. Speaker, if you are delving into issue of admissibility, we have to be careful. The motion has been admitted by the Speaker, and the Speaker considered all facts. Allow my argument to proceed with the greatest respect. My contention, first, is that this motion has met the admissibility threshold in accordance with the rules of this House.
Honorable Minority Leader, I intend not to be arguing
Mr. Speaker,
with
you allowed him
I
to
just want to understand whether
Mr. Speaker, the man argued.
He made an allusion to that
quiet.
particular fact. It may be denied that there is no such case pending before the court. So I humbly want to understand whether a case of that nature is pending. You understand? I'm not delving into issues of admissibility.
He raised this very matter. I am saying that what he's doing is on you. The fact that he talked about a pending matter at the Supreme Court was in the full knowledge of Mr. Speaker. He brought this matter to the attention of Mr. Speaker. This matter was brought to the attention of the Speaker. The clerk to Parliament and I were before the Speaker in his presence, with the Majority Leader. The issues were brought up, and as a result of the issues of court writs, the text of the motion had to be amended. Mr. Speaker later had to look at the court process and did a further amendment before admitting the motion. We've crossed a line. We've crossed a line. And that is why I referred you to Order 103F. This was not the original motion. The original text was under half-hour motion. I have the original text here. It had to be amended and amended again so that we don't go into the realm of the matters before court. And that is why in my second argument, I was adverting your mind to the fact that this motion is not seeking to have this House make constitutional declarations. This motion is not seeking declaratory reliefs. This motion is not seeking for an interpretation of the supreme laws of the land. It is not. This motion is anchored squarely on good practices and governance matters. Mr. Speaker, do not forget that not long ago, we had a matter pending at the High Court in respect of these matters about the collapse of banks, and the applicants petitioned this House. Mr. Speaker ruled that indeed they are facing some civil, they themselves had filed some applications at the court, they were facing some criminal trials, but the issues they had brought were different in form and in shape and required Parliament inquisition. What is before us is not about a matter before the Supreme Court. There are no such parties of personal interest. Of course, I will respect that. If there were, I will respect that. Somebody is before the court asking for some declaratory reliefs in respect of constitutional provision. That is not where I am. That is not the path I've taken. What is before you is talking about governance. I'm not here to move a motion to demand certain declarations. Mr. Speaker, at pre-sitting, the understanding was that the Majority Leader will raise this issue, will respond, and then a pathway would be given for us to proceed. This issue that somebody is rising behind and trying to this thing, it will not work. when we agree in good faith, let's proceed accordingly. That is how I understand the practice in this house. Mr. Speaker, the majority leader is also arguing that this matter, if considered, would affect the rights of certain individuals in court. Whose rights? That is not where we are. That is not where we are. The fact that we are referring to a subject matter and invoking the inquisitorial powers of this house does not mean that because somebody is also asking for the Supreme Court to interpret the Constitution, this house stands estopped. The rule of estoppel is not applicable here. It cannot apply against our regular conduct as enshrined in the Constitution. Mr. Speaker, the argument of sub judice is inapplicable here. The majority leader has expressed his own objections. I respect that. But Mr. Speaker, for the good of this parliament, we need to proceed to move this motion. There is precedence, and I've cited the precedence at the risk of being repetitive. I shall repeat them. I shall go over and then draw the attention of the chair that we've had instances where Ghanaians were facing criminal trials. Ghanaians were pursuing the state in the civil matters, but again petitioned this very house on aspects that they felt that their rights needed to be protected by the people's representatives. What does the motion say? I will go over. The motion is coming under Order 114 of our rules. Order 114, Mr. Speaker, with respect, provides motion on specific matters of urgent public importance. Mr. Speaker, in his wisdom, within his powers of admissibility, has determined that this motion falls under matters of urgent public importance. Mr. Speaker has again found this motion worthy of admissibility. And then, Mr. Speaker, has allowed this motion to be on our order paper. And this is what the motion reads: that this Honorable House considers the directive by the Chief of Staff, Honorable Julius Debra, in a letter dated 3rd February 2025, with reference number SCRDA85/85/01/A, and refers the matter to a committee of Parliament to inquire and to report to the House, as the directive is inconsistent with good governance practices and has consequences. We are not saying that it is in breach. Please, Mr. Speaker, we are not saying that the action is in breach of the Constitution. We are not saying that the action is in breach of any enactment. We say, and has consequences. Mr. Speaker, the language used has been carefully crafted to move away from any courtroom interference. Mr. Speaker, the issue before you is properly before you. Therefore, it is at the point of inquiry that this House, through its appropriate committee, will now consider all the issues, which issues deal with good governance, and report to this House. When the committee reports, This House will now consider the remit of the report, i.e. the findings and recommendations and all. Then we take a decision. Mr. Speaker, for anybody to say that merely moving the motion to bring this matter before the people's representative will amount to interfering in a court process, Mr. Speaker, will be tantamount to denying us our rights as the people's representatives from considering governance issues. Mr. Speaker, our hands therefore will be tied that this House cannot proceed, and any busybody will then use courts to arrest this House. Because as soon as the matter is raised, you say, oh, I have filed a writ. Oh, there's something before the court. Then, Mr. Speaker, how will this House function? But I shall conclude, Mr. Speaker. Mr. Speaker, Mr. Speaker, I shall conclude by submitting that, Mr. Speaker, the issue of admissibility that he is raising in his preliminary objection has long been dealt with. Mr. Speaker, the entire argument that he forcefully put across, if you listen to him carefully, all his argument has to do with admissibility. But, Mr. Speaker, we've long passed that stage. We have long passed that stage. All that he said, that it will prejudice the outcome of a case, there's a matter before court. Mr. Speaker, the law that we operate with in this House, 103, is clear. That before the motion is even considered, it says the conditions for admissibility of motion. So if you don't meet the threshold, you don't get to this level. All that he is saying, as if the motion is now being filed at the clerk's office, as if Mr. Speaker is consulting us for our opinion before admissibility. No, we've gone beyond that. He cannot, it's too late in the day for him to attempt to invite this House on issue of admissibility, unless he wants to challenge the decision of the Speaker for admitting this motion. Mr. Speaker, we cannot allow this argument to stand when there's already a decision taken. Again, for the avoidance of doubt, I will repeat, Order 103F. A motion shall relate to a definite issue and not be the subject matter of an action on which a judicial decision is pending. So that argument he raised, it was a condition precedent that we should meet that threshold. We've crossed that threshold. We've crossed. He cannot now raise a preliminary objection on the ground that there's a judicial matter pending. We've moved past there. In the opinion of the Speaker, prejudice the interest of parties to the action. Mr. Speaker has determined this matter, that the outcome of this motion, the motion in its form and shape, will not prejudice the outcome of any case. The very case is referring to, he brought you to the attention of the Speaker. The Speaker has determined it, that there's no way what is before us would sin against Order 103F. So, Mr. Speaker, he cannot. He is stopped by the decision of the Speaker and Order 103F. If, however, he seeks to challenge the Speaker's discretion on admissibility, he, as the leader of this House, knows what to do.
Honorable Majority Leader, I am being called upon to make a ruling on this matter. I would